Can you talk more about how you can reframe these questions in the legal or constitutional framework that would survive review under Patel versus Garland?
Yeah, I think the most common type of argument is probably due process violation. And we have seen a lot where the agency uses its own evidence without giving you the opportunity to cross-examine the witness. For example, they may say, "We talked to your ex-husband. He said you paid him $10,000, so it was fraud, but there was no sworn statement."
Or a poison pill letter where they have a letter from a former spouse, but they won't let you review the letter, right?
Yeah, or you were not given the opportunity to bring that person to cross-examine. So that would be probably the most common way to frame a constitutional question, due process violation.
Yeah. So procedural due process, you're not being given the opportunity to test the government's evidence. And the way I think of it is if the government were to go ahead and just issue a denial on a case without giving you an RFE, request for evidence, or giving you a notice of intent to deny, if they just say, "We've got this evidence and in our discretion," and they're allowed to deny a case without asking for any extra evidence. But when they do that, they're taking away your ability to build a record and also challenge that finding. So if you had a case where they just outright deny something, that's going to be the case where you have either a Fifth Amendment or a 14th Amendment. I think it's a Fifth Amendment due process challenge saying that the federal government is not giving you your opportunity to challenge their denial.
Yeah, that's right. Another point I want to make is that because I litigate more business immigration cases than removal defense nowadays. The advantage of these business litigations, especially for adjustment of status denial, is that a lot of the individuals are actually maintaining lawful status. So for example, they do have H-1B status, and the adjustment denial does not revoke their H-1B, so they are in lawful status. So they should not be concerned about somehow ending in removal proceeding. Or in other words, it is a tool they can definitely use, and worst case scenario is to just get the case dismissed.
Either they refile, they travel, come back in, seek a visa overseas.
Right. So of course, it's a case-by-case analysis, but they do still have this option open, even if we have this bad decision here in a limited removal proceeding context.
I've got one case. I typically also don't do that much of the removal litigation, but I got pulled in to work on a case where a 751 was allegedly denied, but the person seeking to remove the conditions on their green card never got the denial. Unfortunately, they issued an NTA, USCIS issued an NTA to this person after we filed the lawsuit. And now we're arguing procedural due process. This person never got a copy of the denial. The NTA has no basis, and we want the judge to throw it all out. And we had a motion to dismiss filed against us by the U.S. Attorney's Office for the Southern District of Texas in Houston. We responded. Now we're waiting for the judge to make a decision on that. But I think you're right. I think the business immigration litigation won't be that affected by this, because you're right. The 45 is more of a convenience for those people.
Right. I recently had a case where the client wasn't maintaining H-1B status, and the government denied the I-485 based on the OPT period alleged association with one of those companies that got busted. So we fought back. We just sued the government directly. And the person the government basically just reopened and approved the case. Before the person even ran out of H-1B status.
Nice.
So it is definitely possible.
The way I try to describe it to people is that there's not going to be retribution for filing a lawsuit against the federal government. If they have the ability to NTA someone, it's not retribution. They're allowed to do that. And as long as the client understands the risks and can assess those, and to me, usually in a business immigration context, the risk is really the money that they're investing in the lawsuit. And is it better than refiling an I-140? In the family context, is it better than filing another I-130? And if you already have a denial, If you win either through the negotiation as you're describing, USCIS may reopen, issue an RFE, they might issue a notice of intent to deny, or they might just reopen and approve the case. You've deleted a denial from the record, and that person's immigration record going forward is clean. If they file a new case, they then have to overcome that presumption within the agency that the first denial was correct. So as long as people understand and have their expectations managed, and as lawyers, we're not allowed to guarantee outcomes. We can't take contingency cases on these. So I guess you could take contingency cases, but we're not allowed to promise results. As long as the clients understand that litigation should be a way to give them their day in court and test the government's denial, it shouldn't be any harm to them.